The crimes against humanity refer to specific crimes committed in the context of a large-scale attack targeting civilians regardless of their nationality. These crimes include murder, torture, sexual violence, enslavement, persecution, and enforced disappearance. Persecution against any identifiable group or collective on political, racial, national, ethnic, cultural, religious, gender, or any other as defined in paragraph 3 or other grounds that are universally recognized as impermissible under international law in contention with any act referred to in this paragraph or any crime within the jurisdiction of the court. A state not party to the statute can also accept jurisdiction of the ICC with respect to crimes committed in its territory or by one of its nationals and request the office of the prosecutor to carry out an investigation. To continue, we will listen to the Human Rights Commissioner Chief to give us what is going on within the human rights sector. He is addressing the world on the activities of human rights and their jurisdiction.
Really the cornerstone of the United Nations. Since then, states have established an ecosystem of international human rights bodies. Among them, the 10 treaty bodies, this Human Rights Council, with its universal periodic review, investigations, and special procedures experts, and my office. We are now at a critical juncture, 75 years after the adoption of the Universal Declaration of Human Rights and 30 years after the Vienna Declaration. Against the backdrop of flaring conflicts, the Sustainable Development Agenda dangerously off track, and environmental harm threatening humanity. International cooperation is vital so that we can advance human rights. This is what the United Nations Charter puts forward as a premise. And it is why before this Council session, I will focus my statement on cooperation between member states and the ecosystem of international human rights bodies. A lifeline which is strong because it is made of many cords bound together like a sailor's rope. Poor cooperation leaves states adrift. Selective cooperation weakens that lifeline's force. Mr. President, engaging with a stable field presence of my office is a hallmark of states that are constructively cooperating to advance human rights. 95 states or territories accommodate human rights field presences, and when this statement is uploaded to our website, they will be listed. I pay tribute to their engagement. Let me give you a few examples. Colombia recently extended our field presence to 2032. Our work has considerably contributed to the cause of peace.
We will continue as we have had the introduction.
Accountability for
we will
crimes
join later.
Committed during the armed conflict, as well as a victim.
United Nations Security Council may also refer the matter to the court. According to Article 7.1 of the Roman Statute, crimes against humanity do not need to be linked to an armed conflict and can also occur in peacetime, similar to the crime of genocide. The same article provides a definition of crime that contains the following elements. The ICC prosecutes the perpetrators even if the crimes were not committed in times of war. This brings us to the issue of Southeast governors and the matter of Mazi Nnamdi Kanu and the IPOB, Operation Python Dance 1 and 2, and all other military operations associated with this. It is recognizable that the governors involved were Fein, Ugwanyi, Imo State Governor Rochas Okorocha, Ebonyi State Governor Dave Umahi, and the chairman of the Southeast Governors Forum, Anambra's State Governor Willie Obiano, and Abia State Governor Okezie Ikpeazu, after a recent meeting of the forum. The proscription was announced by the chairman of the forum on September 15, 2017, and was published in Daily Post, Nigerian Daily Post News. Before a case is referred to ICC, the matter involved must undergo investigations, and this has been investigated. The issue of rendition, reasons why Mazi Nnamdi Kanu fled Nigeria, and also how he was renditioned back and the crimes associated with it, the human rights abuses, all this has been investigated and passed through the normal process of United Nations Human Rights Committee, and this is also accompanied with the case of discharge and acquitted on the part of Nigerian Court of Appeal. His continuous detention has been associated with the Southeastern governors who want political dialogue and agreement before they accept the Court of Appeal order. This has led to his continued detention. United Nations Human Rights Council and its Committee on Arbitrary Detention, having disclosed their reports under the United Nations General Assembly Resolution A/RSE/43/173 of 1988, has accepted that Mazi Nnamdi Kanu's detention is inappropriate, unjustifiable, and contravenes the Universal Declaration of Human Rights as long as the group is concerned. The ICC will rely on the report of the United Nations Human Rights Working Group on arbitrary detention and violations of human rights, and those of Human Rights Watch and other local reports and evidence. The opinion catalogued serial human rights violations of Nigeria and Kenya regarding Mazi Nnamdi Kanu, the deprivation of liberty in contravention of Article 2, 3, 7, 8, 9, 10, 11, and 19 of the Universal Declaration of Human Rights, and Articles 2, 9, 13, 14, 16, 19, and 26 of the International Convention on Civil and Political Rights, as found in paragraph 105. Separatist agitation in southeast of Nigeria. The trial of Nnamdi Kanu, leader of indigenous people of Biafra group, agitating for secession of southeast Nigeria on treason and terrorism-related charges, was delayed by preliminary proceedings, including 2 bail applications that the court denied. The judges also struck out 8 of the 15 charges, and finally the Court of Appeal of Nigeria then quashed the remaining, and Nnamdi Kanu was set free and discharged. Then the question is, why has the southeastern governors continued a political dialogue request, and this is where their problem comes in. There is no doubt they must have had agreement with the former president of Nigeria, Mr. Muhammadu Buhari. He was in the office when Nnamdi Kanu was discharged by the Federal Court of Appeal. They failed to comply with the court orders. The former Justice Minister, Malami, was not apprehensive of the disobedience to court order. Therefore, they are all involved in this very case that is now coming up against them. Nigeria is part of international community and signatory to various treaties, including human rights. It has been found that there is a disconnect between the actions of federal government of Nigeria and the commitment to international community and justice they claim to have shown over the years. In solidarity, the citizens in the southeast continue to observe to very extent a sit-at-home order introduced by IPOB in August 2021 as a means of pressurizing the government to release Mr. Kanu. The order requires citizens in southeastern states to stay at home and public places to stay closed on Mondays and any other day that is announced, including days Kanu is set to appear in court. Security forces and vigilantes opposing the separatists have also been implicated in abuses, including extrajudicial killings in the region. Government agencies see Nigeria as a compliant nation in relation to the acceptance of international criminal cases or justice, but they have vehemently refused to comply with the recommendations of United Nations Human Rights Working Committee on Arbitrary Detention, and this has heightened the desire for the case to go to ICC for proper determination, and those who are involved will go there to answer the questions themselves. American legal luminary Bruce Fein, the special counsel to the detained leader of indigenous people of Biafra, Nnamdi Kanu, says the detention violates international law. This means that the Nigerian government chooses when to accept, what to accept, and how to accept international justice. But, however, the relevance of international justice in solidarity makes it possible to accept international signed obligations. That is where Nigeria has a problem. They must have been refusing, but they have signed obligations that they must accept international justice, and the jurisdiction of Nigeria is within the United Nations. These may also give rise to universal jurisdiction. Universal jurisdiction under international law includes the treaties, international treaties like the United Nations Convention Against Torture or the Geneva Convention for War Crimes and the General Custom of States. That is the customary international law under which war crimes and crimes against humanity could be considered. In the recent times, there is bombing, killings in various parts of Imo State by the Nigerian military forces. The killing of members of the IPOB or any other group is considered by the United Nations Convention on the Prevention and Punishment of Crime of Genocide. causing of serious bodily harm or mental harm to members of the group, deliberate inflicting on the group conditions of life calculated to bring about its physical destruction in the whole or part. In addition, the ICC statute has defined crimes in internal conflict to include acts like intentional attacks against civilian populations, such as or against individual civilians not taking direct part in hostilities. These are the areas. Intentionally directing attacks against buildings, materials. These are the things the Nigerian forces and the governors who invite them has to take precaution of. With this, we come to the end of this very program. Do not fail to subscribe, like, share, and also leave your comment. Thanks and God bless you all. Bye. The row between IPOB leader Mark